Yes, I am. Miss Bankston seems to be in a little bit of distress. She's over by the holding area.
Bankston.
She's going to be coming up here right now with the assistance of the deputy.
You're gonna sit in this red chair over here.
Okay. So she can hear me?
It'll be just a second. Yes, she can hear you. And it'll be just a second. She'll be sitting in the chair next to me.
Okay.
This is Miss Bankston. Right.
Okay. All right. Good morning. You are here for a hearing because of a municipal hold in the city of Edgewater. The purpose of this session is to address the hold and for you to consider a resolution to your case. You have the following rights before this court. You are presumed innocent of the charges against you. That presumption of innocence remains with you until you either plead guilty or are found guilty at trial. It is the prosecution's burden to prove each charge against you beyond a reasonable doubt. While you are in custody and facing a possible sentence to incarceration, you have the right to be represented by an attorney. Therefore, the court will conditionally appoint Mr. Oldham to represent you for purposes of this hearing. Throughout this case, you have the right to remain silent. No one can force you to make any statements about the charges against you, and any statement that you make must be a voluntary one. We have a recorder running here today, so any statements that you make could be introduced at trial. If your case goes to trial, you'll have the right to testify or not testify at the trial. You also have the right to cross-examine the witnesses against you, and you have the right to call witnesses on your own behalf. If you request them, our court clerk will issue you subpoenas that you can have served on witnesses to make sure they attend court. You have the right to appeal the decisions of this court to a higher court. To do that, you would need to file a written notice of appeal in the Jefferson County District Court, which is out in Golden. That would have to occur within 35 days of final action by our court. The maximum penalty that our court can impose depends upon the type of charge you are facing. If you are facing a criminal offense, the maximum penalty is up to a $999 fine and up to a 180-day jail sentence. The prosecutor has extended a plea offer for your consideration, and I will discuss the offer with you shortly. I am not bound by the sentence recommendation in the plea agreement. However, I will not impose more than what the prosecutor has recommended. All of the penalties I've mentioned are maximum penalties. I am required by the Supreme Court rule to tell you about the maximum authority that I have. As far as our process goes, I'll tell you about the charge or charges against you. We will discuss the plea offer from the prosecutor. If you decide to accept the offer, I will take your plea and we'll go forward with sentencing. That is one way to resolve your case. You always have the right to plead not guilty to the charges against you and set your case for trial. If you decide to set your case for trial, you have the right to a trial in front of a judge. If you are facing the possibility of a jail sentence for your charge, then you have the right to choose between a trial in front of a judge or a jury trial. If you decide that you want a jury trial, you are required to do two things. First, you have to request a jury, and second, pay a $25 jury fee within 21 days of the date that you first pled not guilty. If you were to plead not guilty today, the 21st day would be January the 23rd. I can waive the jury fee for you if I determine that you are not able to pay the fee. If you have not made the written request for the jury trial and paid the $25 jury fee or asked me to waive the jury fee within the 21-day period, then you will have given up your right to a jury trial and your trial will be in front of a judge. So one moment. The court calls case 51439, City of Edgewater versus Cal Bankston. Ms. Bankston, on July 14th of 2024, you were charged with resisting arrest and theft. I think the amount was about $460. This is alleged to have occurred at 1985 Sheridan Boulevard. You were served with the summons in order to appear in court on September 3rd, 2024, and you failed to appear. So a $400 cash surety bond or warrant was issued for your arrest. You appeared on October 15th in custody. The bond was converted to a PR bond. You were ordered to appear back in court on November the 12th. You failed to appear on that date, and a warrant issued in the amount of $600 cash surety. It looks like you were booked in on December 31st. So if you were to resolve your case today, it would be 3 days. Credit for time served. The prosecutor has extended a plea offer to you. It's to plead guilty to the theft, dismiss the resisting charge, 60 days jail, and close the case. Mr. Oldham, did you need some time to speak with Ms. Bankston?
I want to know what she just said by 3 days time served. Does that mean I have served my time and the case is closed?
No.
I'm sorry, did you have a question, Ms. Bankston? What was your question?
No, I would like to know if that was 3 days time served and the case is closed.
I was letting you know that if you pled guilty and were given a jail sentence, that you would be, I could take into consideration the 3 days credit for time served, but the prosecutor's offer is for you to plead guilty to the theft charge with 60 days jail.
No, thank you. I would like to take it to jury.
Mr. Oldham, did you want any additional time to speak with Ms.
May
Bankston?
I also request the $25 jury fee to be waived at this time, Your Honor? That's my final decision. I don't need advisement.
Okay, so you don't want to
think
speak. Mr. Oldham?
Yes, I was trying to respond to your question. Do I want more time? I don't think it would be fruitful.
Okay, no problem. And Ms. Bankston, at this time, you would like to enter a not guilty plea?
Like I said, Your Honor, I would like to go to jury. I would like to take it to trial. And I'm
Okay.
requesting at this time, Your Honor, to waive the $25 jury fee.
Okay. All right. Because Ms. Bankston is in custody, the court will officially appoint Mr. Oldham to represent Ms. Bankston and find that she's eligible for representation by Mr. Oldham. The court will enter a not guilty plea. And at this time, Mr. Oldham, would you be requesting discovery?
Yes.
All right, the court will grant discovery pursuant to Brady and Rule 216. And we'll get jury status date and a jury trial date. Question, Robert, we may need to consult with Ms. Rogers about her availability for a trial. Should we set the date, and then if she's or her witnesses aren't available, we can look at a different date?
So I don't know about her witnesses, but on March 11th is our next jury trial date that we have set aside for jury trials, the second
Okay.
Tuesday of March.
Okay. And Robert, what speedy trial date do you,
Sorry,
what speedy trial date do you have?
I have April 4th or April 3rd, 2025.
Thank you. All right, and then what time will we set for jury trial, March 11th?
9 a.m.
Okay, and then jury status date?
We could probably do 3 weeks before that on February 18th
Okay. What time do you suggest?
at 11 a.m.
Okay. Mr. Oldham, would you like some motion deadline dates at this time, or did you want to reach out to Robert about that later, or what are your thoughts?
I'm at your disposal, Your Honor. If you want to set it now, that'd be fine, or I can set it with Robert at a later time. I'm talking to
Okay.
him on the telephone or in
Okay.
person. On behalf of Ms. Bankston, Your Honor, I would like to ask the court to order that a PR bond be set in this case. She has a case in the Jefferson County Courthouse that I believe it's a felony case, and she was granted a PR bond on that case within the last couple days. I don't know exactly when it was, but she, according to the jail records, she does have a PR bond for that Jefferson County case. I don't know what the return date is, but in lieu of that, in light of that, rather, I would like to ask for a personal cognizance bond for Ms. Bankston while we're pending the trial date.
Okay, I just need a little more information. Ms. Bankston, I understand that you want to set your case for trial, and that's fine. But can you tell me a little bit about your ties to the community? Are you still living in Lakewood?
Yes, I'm still living in Lakewood.
Okay, are you currently working?
Yes, I'm currently working.
And is that full-time?
It's part-time.
If I were to consider issuing a PR bond, is there anything that would prevent you from getting to court?
No, Your Honor.
Okay, and do you know where our court is in Edgewater?
Yes, Your Honor.
Okay. Is it your request to be released today?
Yes, please.
Yeah, just waiting for that paper to come through with the final charges and stuff.
All right, the court will note that there are two failure to appears. However, since Ms. Bankston does live in the metro area, has confirmed an address in Lakewood, and is currently working part-time, the court will grant a PR bond in the amount of $600, so to be a $600 PR bond. Given that, Robert, should we set for a pretrial conference, because Ms. Bankston may need to actually apply for Mr. Oldham's representation if she's going to be out of custody?
I suppose, yeah, I think that she's not being held on anything else. We could probably do it a little quicker, and
Okay.
and then we could check with the prosecutor on dates and maybe not set the trial date yet.
Okay. So Ms. Bankston, since I have issued a PR bond, we're going to set you for what's called a pre-trial conference. That doesn't mean that you still can't go to trial on your case. It's just, it would give you some time to come into court to apply for representation by Mr. Oldham, unless you wanted to secure your own private attorney. And then we could set trial dates at that time.
I understand.
Are you okay with that?
Yes, I understand, Your Honor.
Okay. And so at this time, are you okay with me withdrawing your not guilty plea as of today? And then you can enter your plea of not guilty when you come to court? Or I would ask Mr. Oldham to talk to you about waiving speedy trial.
Do you understand what speedy trial is?
So,
It will be
Mr.
on the
Oldham,
date that you mentioned in March. I think we already decided that I requested trial. I'm not sure what's going on now.
okay, so I'm going to give you just a brief moment to speak with Mr. Oldham, and he can clear up any questions that you have. So just one moment. Go ahead, Mr. Oldham, if you want to mute.
Thank you. All right. Your Honor,
Yes.
I think we can go back on the record.
Okay.
Ms. Bankston, we've talked about her speedy trial rights, and she does want to waive her speedy trial rights. And I explained to her that we can go over, and if you would please, go over the dates that she's expected to be in court between now and the trial.
Okay, sure. So first, let me just inquire of Robert. Robert, should we set for February 4th for Ms. Bankston to come in?
Well,
That's not trial. That's not trial.
So that would be fine. I think she might even be able to get in on the 21st though of January.
Oh, that's fine too. Okay, that's fine. All right, let's set for January 21st.
That's to go to the courthouse.
What time, Robert?
10:30 a.m.
Okay, 10:30. So the court will note that that Ms. Bankston has entered a not guilty plea. We will waive, she has agreed to waive speedy trial. We will set you for January 21st, 2025 at 10:30. And on that date, since the prosecutor will be present, we can confirm a jury trial date. Okay, Ms. Bankston?
Yes.
Okay.
Yes, Your Honor.
Okay, so as a condition of the PR bond, I am ordering that you not trespass to the Edgewater Marketplace that's between 17th and Sheridan and 20th and Sheridan. Do you understand?
Yes, Your Honor.
Okay, and we will see you in court on January 21st at 10:30.
Yes, Your Honor.
Okay, have a good day.
Yeah. Best day of my life.
This is me, if you want to give me a call to talk about the case. Do you want this or not? We don't have to take it.
All right, hanging up